I would like to call this meeting to order. Will the clerk please take roll call attendance?
Madam Chair,
Here.
Senator Archambault, Senator Reptakis,
Here.
Senator Burke,
Here.
Senator Oyer, Senator Oyer,
You are on mute, Senator Oyer.
Here.
Senator Lombardi,
Here.
Senator Quesada, Senator Rogers.
Here.
You have 6 members present. There's a quorum.
Thank you very much. We have 6 bills on the agenda for consideration this afternoon. I would like to address those first before we begin hearing the others. The first is Senate Bill number 65 by Senator Miller. We have a sub-A on this bill. May I have a motion to indefinitely postpone Senate Bill 65 and bring forward to the committee Senate Bill 65 sub-A?
So moved.
Thank you. Senator Lombardi makes that motion, seconded by?
Senator Oyer.
Thank you, Senator Oyer. Mr. Clerk, may I have a roll call vote, please?
Madam Chair,
Yes.
Senator Reptakis,
Yes. Yes.
Senator Burke,
Yes.
Senator Oyer,
Yes.
Senator Lombardi,
Yes.
and Senator Rogers.
Yes.
There are 6 in the affirmative and none in the negative.
Thank you. And the bill is properly before this committee. The sub-A, if you remember, this act would exclude the possession of buprenorphine from those controlled substances that can result in criminal penalties. We've passed this bill before. The sub-A makes 2 changes. First, it fixes a typographical error on page 1, line 1. And second, it adjusts a reference to a definition on page 1, line 6. 21-28-1.02 is changed to 21-28-1.02. Other than that, do any committee members have any questions? Seeing none at this time, may I have a motion to pass Senate Bill 65 sub-A, please?
So moved.
Thank you. Senator Lombardi makes that motion, seconded by?
Senator Oyer.
Thank you, Senator Oyer. Mr. Clerk, may I have a roll call vote, please?
Madam Chair,
Yes.
Yes.
Senator Reptakis,
Senator Archambault. Yes.
Senator Burke,
Yes.
Senator Oyer,
Senator?
Yes.
Senator Lombardi,
Yes.
and Senator Rogers.
Yes.
There are 6 in the affirmative and none in the negative.
Thank you. The vote is unanimous, and it passes to the floor. The second bill is Senate Bill number 263 by myself. We have a sub-A also on this bill. May I have a motion to indefinitely postpone Senate Bill number 263 and bring forward to the committee Senate Bill 263 sub-A 2?
So moved.
Thank you. Senator Lombardi makes that motion, seconded by?
Yes. Senator Oyer.
Thank you, Senator Oyer. Mr. Clerk, may I have a roll call vote, please?
Madam Chair,
Yes.
Yes.
Senator Reptakis,
Yes.
Senator Burke,
Yes.
Senator Oyer,
Yes.
Senator Lombardi,
Yes.
Senator Rogers,
Yes.
and Senator Quesada.
Senator Quesada is present for the record. And Senator Quesada, do you have a vote on this?
Doesn't have any microphone attached right now.
Okay, there's 6 in the affirmative and none in the negative.
Okay, the vote is 6 in the affirmative, no negatives at this time. And the bill is properly before us. If you recall, the bill before you raises the legal age to purchase tobacco products, including electronic nicotine delivery systems, from 18 years of age to 21, which will make the age to purchase tobacco in Rhode Island consistent with federal law. After the Judiciary Committee heard this bill, we asked the state agencies that would be most impacted by this legislation to closely review it, because we've learned that tobacco enforcement can be very technical. In response to that request, the Department of Health, the Department of Revenue Taxation, and Department of Behavioral Health, Developmental Disabilities, and Hospitals tweaked the legislation, which gives us sub-A. Most importantly, what this bill does is align with Rhode Island federal law. On December 20th, 2019, federal legislation was signed into law raising the minimum legal tobacco sales from 18 to 21 nationwide. Most of the changes in the bill are very, very technical and make the bill consistent with federal law. Person, for example, became individual approximately 12 times. E-cigarettes became electronic nicotine delivery system products. Does anyone have any questions on the bill? There are several other changes to the bill, but mostly technical in nature. Yes, Senator Archambault.
Just a quick question for you. I know Massachusetts, they defined David one step further where they eliminated menthol tobacco products. So this bill, we don't micromanage getting into that venue of technically defining, for example, like a menthol cigarette, or I'm not sure if we can call it a flavored tobacco product. I know it's a big issue that Massachusetts went one step further. So we don't define anything in the bill, because I'm looking at it closely and I didn't see any language or the sub-A.
No, not related to menthol.
Great, thank you very much.
You're welcome. Any other questions by committee members? Seeing none at this time, may I have a motion to pass Senate Bill 263, Sub A2?
So moved.
Thank you. Senator Lombardi makes that motion, seconded by? May I have a second, please?
Senator Oyer.
Thank you, Senator Oyer and Senator Rogers. Mr. Clerk, may I have a roll call vote, please?
Madam Chair.
Yes.
Senator Raptakis.
Yeah.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Rogers. There are 6 in the affirmative and none in the negative.
Thank you very much. Third is Senate Bill number 318 by Senator Archambault. We have a sub-A also on this bill. May I have a motion to indefinitely postpone Senate Bill 318 and bring forward to the committee Senate Bill 318 sub-A, please?
So moved.
Thank you, Senator Lombardi, and seconded by Senator Raptakis. Mr. Clerk, may I have a roll call vote, please?
Madam Chair.
Yes.
Senator Raptakis.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
And Senator Rogers.
Yes.
There are 6 in the affirmative and none in the negative.
Thank you very much. The bill is properly before this committee. With regard to the sub-A, most of the request for the changes came from the Attorney General's office. They wanted to clarify that, quote, the vulnerable road user is someone who is supposed to be in the roadway and is not acting in a negligent manner. It references Rhode Island general law to clarify, 1, a pedestrian who's acting in compliance with Chapter 18, Title 31, a bicyclist, a person riding on or driving a wheelchair, 6, a person using a skateboard, inline skate, or roller skates, and number 8, a person riding a scooter, quote, who is acting in compliance with Chapter 19.1 of Title 31. Also adding the language on page 1, line 15, who is the proximate cause of injury, to be clear that their actions set in motion a relatively short chain of events that could have reasonably been anticipated to lead to the damages. Does any member have any questions? Okay, seeing none at this time, may I have a motion to pass Senate Bill 318 sub A? I see that Senator Archambault is present. He's going to make that motion. May I have a second?
Second.
Thank you so much, Senator Lombardi. Mr. Clerk, may I have a roll call vote, please?
Madam Chair.
Yes.
Senator Archambault.
Yes.
Senator Raptakis.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
And Senator Rogers.
Yes.
There are 7 in the affirmative and none in the negative.
And the bill passes to the floor. I do see Senator Ana Casada online. Senator Casada, would you like to be recorded in the affirmative on any votes missed?
Yes, please.
Thank you very much. Also, Senator Archambault, would you like to be recorded in the affirmative on any votes missed?
Yes, please, Madam Chair.
And it does not change the outcome. Thank you very much. Our fourth bill on the agenda for consideration this afternoon is Senate Bill 518 by Leader Mccaffrey. And this act would further delineate the definitions of felony misdemeanor and petty misdemeanor. It's identical to the bill that passed the Senate in 2018. It was originally part of the Justice Reinvestment Package. Any questions by committee members? Seeing none at this time, may I have a motion to pass Senate Bill 518?
So moved.
Thank you. Thank you, Senator Lombardi, and seconded by Senator Reptakis. Mr. Clerk, may I have a roll call vote, please?
Madam Chair.
Yes.
Senator Archambault.
Yes.
Senator Reptakis.
He said yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Senator Archambault
Yes.
must have speakers.
Senator Quesada.
Every time he unmutes.
Yes.
all that-
Senator Rogers.
Yes.
There's 8 in the affirmative and none in the negative.
Thank you very much, and the bill passes to the floor. Next up is Senate Bill number 676 by Senator Oyer. Let's see. This act would provide that violations of Chapter 34 of Title 31 pertaining to rental vehicles are civil violations subject to the jurisdiction of Rhode Island Traffic Tribunal. And this is being sponsored on behalf of the Judiciary. Any questions by committee members? Seeing none at this time, may I have a motion to pass Senate Bill 676? I believe that's by Senator Oyer. May I have a second, please?
Second.
Second, thank you, Senator Quesada. Mr. Clerk, may I have a roll call vote, please?
Madam Chair.
Yes.
Senator Archambault.
Yes.
Senator Reptakis. Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Quesada.
Yes.
Senator Rogers.
Yes.
There's 8 in the affirmative and none in the negative.
And Senate Bill 676 passes to the floor. Finally, the last up for consideration this afternoon is Senate Bill 681 by Senator Frank Lombardi on behalf of the Judiciary. And this act, just as a reminder, would eliminate the provision of a person who solicits a ride in a motor vehicle or backs up a motor vehicle on a freeway is guilty of a misdemeanor. Any questions by committee members? Seeing none at this time, may I have a motion to pass 681 made by Senator Lombardi and seconded by Senator Archambault? Mr. Clerk, may I have a roll call vote, please?
Madam Chair.
Yes.
Senator Archambault.
Yes.
Senator Reptakis. Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Quesada.
Yes.
And Senator Rogers.
Yes.
There are 8 in the affirmative and none in the negative.
And the bill passes to the floor. Thank you. Okay, next we have 18 bills scheduled to be heard this afternoon. In keeping with existing virtual protocol for this committee, I would ask for a motion to hold all 18 of these bills before us for further study.
So moved.
Motion made by Senator Archambault, seconded by
Second.
Senator Quesada. Mr. Clerk, may I have a roll call vote, please?
Madam Chair.
Yes.
Senator Archambault.
Yes.
Senator Reptakis. Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Quesada.
Yes.
And Senator Rogers.
Yes.
There are 7 in the affirmative and none in the negative.
And the vote's unanimous. They're held for further study. In an effort to utilize both the sponsors and the public's time more efficiently while conducting these hearings virtually, I will ask each of the sponsors, if they're present, to introduce and explain their bill. I do want committee members to know that we do have a finite time frame to work within tonight, as there's a health committee meeting scheduled to start at 5 p.m. in this room. So I would kindly ask both the sponsors and the public to do their best to keep their comments between 3 and 4 minutes, if possible. If we can't finish the agenda this evening in time, we'll have to move the remainder of the bills to another night. So we'll do our best that we can under the circumstances. So the first bill that we have on the agenda is 684 by Senator Archambault on behalf of the Attorney General. Senator Archambault.
Thank you, Madam Chair. This bill is a bill that would essentially enable the Attorney General's office to stand in the shoes of consumers when it's protecting them under deceptive trade practices. By a loose analogy, in Massachusetts, they have a law called, that we short in the way we discuss it, as 93A. And 93A means that you're able to hold someone accountable civilly if they don't try to work out a resolution for treble damages. The genesis of this bill, although it's not exactly like 93A, is similar in the sense that it would enable the Attorney General's office to limit the exemptions that Deceptive Trade Practices Act actually enables businesses that are regulated by state and federal agencies to have those. And so it would provide that the violations of the Deceptive Trade Practices Act or any injunction issued pursuant to that Trade Practices Act shall result in civil penalties. And essentially, it's going to enable the Attorney General to bring its consumer protection laws out of last place. We're in the very back of the pack in the whole country, and put them at the forefront of being able to protect consumers. I don't think we're going to hear any blowback from any consumers or anybody who's in favor of helping the state. It's a very important bill. It's a top priority to the Attorney General's office, and any company essentially that's complaining or whining about it, I think, should be very much subject to the oversight of the Attorney General's office, and I say that sincerely. I'll take any questions on it. Thanks.
Any questions of Senator Archambault? I see that the Attorney General is on at this time. Would you like to make comments on this bill, General?
I would, Chairperson Coyne. I would. Thank you, and I will be brief, recognizing that the committee has a limited amount of time. I want to thank you, Chairperson Coyne, the members of the committee, and Senator Archambault in particular for his advocacy. I don't know that I need to add an awful lot to what he just said, but let me say this: that our consumer protection statute, as it exists today, is nothing like what this legislature intended when it first passed it many, many years ago. It has been interpreted by our courts, unfortunately, to effectively eliminate my office from getting involved in any consumer protection issue where the entity is regulated by somebody else. And I will tell you, not only is it, in my view, critically important that we have that authority, I know that members of this General Assembly feel that way as well. And I'll explain why. When there was a gas outage on Aquidneck Island, there was a call from this body, the Senate, from my office to investigate. We can't do that under this statute as it currently exists because utilities are regulated by the PUC. Look, I understand that the DPUC and the PUC have an ability to investigate, but I think the people of the state want and deserve a situation where their Attorney General can act independently on their behalf as a people's lawyer. There's just, in my view, no reason why we should be among the terrible twos, along with Michigan, that aren't able to advocate on behalf of consumers in this state in an effective way. You know, I know that this will benefit consumers. Let me address any issues that may be raised by some portions of the business community. First of all, when businesses don't act the right way, when they don't treat consumers the right way, they're taking advantage of those businesses that do. That's number one. And here's the other thing. This is a model statute. What that means is that some version of this statute exists in all of the 50 states. So every business that is doing business in another state is already subject to this kind of investigative authority from their Attorney General. So if any entity that's complaining about this bill does business in any other state, what they're effectively saying is they're not willing to be regulated in Rhode Island the way they're being regulated somewhere else. And I think we all know what the answer to that claim should be. So I'm happy to answer any questions that the committee has about the bill. And I would, of course, advocate and ask that it be passed out of committee. Thank you very much for your time.
Thank you, General. Do any committee members have any questions of the Attorney General? Senator Archambault?
Thank you, Madam Chair. I just want to thank the General for making this consumer bill his top priority. It just shows where your heart is, putting the people first. It's a great bill, very important bill, and it'll create comedy for all the reasons you've said. So I hope that it's able to pass this session. Thanks, General.
Thank you, Senator.
Thank you, and I believe you're testifying on another bill. We'll get to that shortly. Thank you.
Thank you.
If there are no questions of committee members, we're going to move to the next bill, which is 718. I don't see Leader Mccaffrey on. It's an act relating to property, residential Landlord and Tenant Act. It requires a landlord to obtain and have in full force and effect a general liability policy of at least $100,000 for those persons injured on the premise due to the negligence of the landlord. Does anybody have any questions related to this bill? Seeing none at this time, we will move to the leader's next bill, which is Senate Bill number 724, sponsored on behalf of the courts, an act relating to public finance, state funds, adds the Judiciary's Indirect Cost Recovery Supreme Court Victims' Rights Information, Rhode Island Supreme Court Disciplinary Council, and the small claims mediation accounts to the list of restricted receipt accounts which are not subject to indirect cost recovery. Does anyone have any questions at this time on this bill? Seeing none, we will move to Senate Bill number 726, and I believe we have Julie Hamill from the courts who are going to speak to some of these court bills. Also introduced on behalf of the courts, an act relating to criminal offenses law practice. It provides that the rules and unauthorized practice of law committee would be approved and promulgated by the Supreme Court. Any questions of anybody? Seeing none. The next bill is Senate Bill number 729, introduced on behalf of the Attorney General, Senator Quesada, an act relating to courts and civil procedures, procedure generally, causes of action. Senator Quesada.
Thank you, thank you, Madam Chair and member of the committee. What this bill do is it give a tool to the AG's office, but to the public too. If you were discriminated, or you feel you were discriminating for race, for religion, for disabilities, you will be able to sue, not criminal, but civil. Have a civil right to be able to take that person to court for any damage that you receive. But at the same time, now in the time that we live in, and we're seeing so many hate crimes going around, especially in the Asian community, African American community, and minority of people of color, I think it's a great bill to pass, because it will give this person the opportunity to bring these people to court and give the AG's office the opportunity to prosecute anybody who make those crimes. And I will answer any question you may have. I'm sure the AG's office would be more able to explain it better than me, but that was the main thing of the bill, is to give the tool to the AG's office, but at the same time to the person who get discriminated for any reason now. Thank you.
Thank you very much. I know we do have another member of the Attorney General's office who is going to speak to 729, your bill, later on in the afternoon. Thank you. Any questions of committee members for Senator Quesada? Seeing none at this time. The next bill is 730. Senator Archambault has this bill on behalf of the Attorney General, an act relating to criminal procedure, county grand juries. Senator Archambault.
Thank you, Madam Chair. Essentially, this bill would permit the grand jury to issue reports, and it provides a review process for that, and has a 5-year sunset. I know the General's here and wants to speak on it. He could go into more detail. Thank you.
Thank you very much. General, welcome back again to the committee. Would you like to speak to this bill?
I would briefly thank you, Chairperson Coyne. Again, appreciate the opportunity to speak to the committee, and to Senator Archambault, again, in particular, for his willingness to sponsor this legislation and advocate for it. Just to kind of break this down very simply, what this statute would allow us to do in a case where the grand jury does not issue an indictment would be to issue a report which explains the grand jury's findings. I think this tool in the toolbox, which I don't anticipate would be used very often, is just critically important for us for both purposes of transparency and for building public confidence when we conduct particularly sensitive investigations. So, for example, we're seeing across the country instances where members of law enforcement are involved with the public in ways that lead to very bad outcomes. And so the responsibility may or may not lie with the police officers. In some instances it does, and some instances it doesn't. But the reality is that kind of matter is falling into the hands of prosecutors like me across the country more and more than it ever has. And we owe the public an explanation as to what we find, whether we get an indictment or whether we don't. And when you go to the grand jury to do these investigations, and many times you have to, sometimes you don't have to, and I had the ability not to have to do that last fall, but when you have to go to the grand jury because you need the grand jury subpoena power to get information that you can't get otherwise, if the grand jury does not return a true bill, meaning does not return an indictment, what a prosecutor can say about the result is limited to basically the grand jury did not return an indictment. I think whether it be in the context of allegations of excessive force involving police officers or other, I think, limited situations, I think being able to explain why the result was what it was would really advance the public's interest. You know, it will build confidence in the outcomes, and it promotes transparency. You know, some ask, well, what about the rights of someone who's investigated having sort of that information out in the public? And there are due process protections built into our statute, and they are these. That before that report can issue, anyone who is identified in the report is notified of it. They have an opportunity to go to the Superior Court presiding justice to object to the report being released or the report being released with their name in it. That proceeding is and of itself sealed, because otherwise, obviously, the fact that they're in the report, if that were public, that proceeding, that information would be out there. And then, of course, if the presiding justice were to rule that it should be released, then there's yet another due process protection built in, and that is that matter can then be appealed to the Supreme Court. So I believe that this tool in the toolbox is a necessary one, and we strike the right balance between having something which can explain to the public why we took a certain action, and at the same time build in the kind of protections that I think all of us want to be there. You know, I've been in office now for a little bit over 2 years, coming up on 2.5 years, and I've already had a number of cases where this issue has come up, and this inability to speak about the result, or I've had to make strategic decisions that are different than they would have been had I had this tool, because I just don't know what the outcome is going to be. And I think this is a really important way of achieving transparency. And again, it builds in the kind of protections I think all of us understand and accept are necessary. And I want to say this too: this is not a novel concept. It exists in many other states around the country. And there is a federal analog. And so I would advocate for the use of this tool, for the ability to have this tool, so that we can achieve better results for the public, and most importantly, build confidence in the results of our investigations. I'm happy to take any questions, and again, thank the committee for your time.
Thank you, General. Any questions for the Attorney General at this time? I don't see any. Thank you for joining us this afternoon. We appreciate your testimony.
Thank you, Chairperson.
Sure. Next, we have my bill, also sponsored on behalf of the Attorney General, Senate Bill Number 731, an act relating to criminal procedure, interception of wire and oral communications. This legislation would add to the designated offenses to authorize a wiretap in any felony violations of the human trafficking law. Any questions? Okay, seeing none. The next bill is Senate Bill 733 by Senator Frank Lombardi, an act relating to courts and civil procedure on particular actions, contribution among joint tortfeasors. Senator Lombardi.
Thank you, Madam Chair. Ladies and gentlemen of the Senate, what this bill is going to do is seek to repeal the old law which allowed for a joint tortfeasor to receive the greater of the benefit, the amount of money that he paid by a released tortfeasor or the percentage of fault attributed to that released tortfeasor. Under this act, it would just limit the credit received by the joint tortfeasor to the amount of money that was paid, puts it in line with more parity in the situation when you have two or more people responsible, two more entities responsible for a particular act. And I'll be happy to answer any questions.
Any questions for Senator Lombardi on this bill? I don't see any at this time. Thank you, Senator. The next bill is Senate Bill number 735, sponsored on behalf of the courts by myself, an act relating to courts and civil procedure. Courts, court administration, it invests the Chief Justice of the Supreme Court with the explicit authority to address issues affecting the conduct of judicial business and order whatever responses he or she deems necessary. Do I have any questions of committee members? None at this time. Thank you. The next bill is Senate Bill number 736 by Senator Archambault, an act relating to courts and civil procedure. Procedure generally, causes of action. Senator Archambault.
Thank you, Madam Chair. This act eliminates the defense for a manufacturer or seller in a product's liability case, and that a substantial cause of death, injury, or damage was a subsequent alteration or modification of the product. And liability would be determined by comparative negligence. It puts it more in parity with other states, and it allows more objectivity. I'll take any questions.
Any questions for the senator? Seeing none at this time, thank you. The next bill is Senate Bill number 795 by Leader Mccaffrey, an act relating to state affairs and government, Department of Attorney General. Requires General Treasurer to allocate 30% of all settlement proceeds from multi-state initiative to the Attorney General restricted account. Any questions? I don't see any questions at this time. We'll move to the next one. Senate Bill number 803 by Senator Archambault, an act relating to criminal procedure, sentence, or execution. Senator Archambault.
Thank you, Madam Chair. As I'm reading this bill and the squib about it, and I am thinking about a case I actually have, a hate crimes case that I'm prosecuting right now. I've prosecuted several in the past. And what this act would do is it would amend the Hate Crime Sentencing Act to add gender identity and expression to protected groups thereunder. Right now, if you were to use a racial epitaph in someone, and that's prosecutable. But this would essentially add gender identity expression to the protected groups, and it would clarify that sentencing enhancements for hate crimes are permitted in instances where the defendant's either motivated in whole or in part due to the victim's status as a member of that protected group. And it permits a judge to sentence a defendant to community service or an educational class to the community harmed by the defendant's actions, which I think is a very nice part of the judicial discretion here, and the remedy that could help somebody get rid of that darkness inside them. Take any questions. Thanks.
Any questions for Senator Archambault? I don't see any at this time. Thank you. The next one is Senate Bill 422, also by Senator Archambault, an act relating to fiduciaries, Uniform Directed Trust Act. Senator Archambault.
Thank you, Madam Chair. This act permits the settler of a trust to designate a trust director, who shall be a person other than the trustee, to direct actions relative to the trust and pursuant to any power of direction. And it would essentially apply new and previously created foreign and domestic trusts. Excuse me, it would apply to new and foreign domestically created trusts. Thank you.
Any questions of Senator Archambault? I don't see any at this time. Thank you. The next bill is Senate Bill 673 by Senator Frank Lombardi, an act relating to corporations, associations, and partnerships. Partnerships, Rhode Island Partnership Act. Senator Lombardi.
Thank you, Madam Chair. Ladies and gentlemen of the Senate, Madam Chair, if you would indulge me, I could actually talk very briefly with respect to 673, 674, and 826 on our docket today. Essentially, one act will conform with the Uniform Partnership Act of 1997, and the other with the Uniform Limited Partnership Act. And 826 is a similar bill, and I think there was just a chronological problem between our communication and that with the Uniform Code individuals. I know that we have Uniform Code people that will be speaking today. but essentially we are trying to get in line with what the uniform acts are in the area of partnerships and in limited partnerships around the country. And I'll certainly be happy to answer any questions.
Thank you, and thank you for bundling those three bills because they're all very similar in nature. Any questions of Senator Lombardi? Seeing none at this time, we will now move to Senate Bill 801 by Senator Archambault, an act relating to courts and civil procedures, procedure generally, Uniform Foreign Country Money Judgments Recognition Act. Senator Archambault.
Thank you, Madam Chair. This act establishes policies and procedures required for the recognition of and enforcement of foreign country money judgments and registration of Canadian judgments by the Superior Court. I'd be open to any questions.
Any questions of Senator Archambault? I do not see any at this time. And finally, Senate Bill number 802, also by Senator Archambault, an act relating to state affairs and government, Uniform Unsworn Declaration Act. Senator Archambault.
Thank you, Madam Chair. This act will give an unsworn declaration under the penalty of perjury the same effect as a sworn declaration, subject to the same criminal penalties for perjury. It makes unsworn the same as sworn. Take any questions. Thanks.
Any questions of Senator Archambault? Seeing none at this time. Thank you to the sponsors for their testimony tonight. Now we'll take testimony from the public. For those members of the public who are signed up to testify, if you would kindly, I know there's several of the witnesses that we have that are going to be testifying on multiple bills. I know that we have a finite amount of time. I've already explained this to the sponsors. I'll just reiterate for the public that if you would kindly keep your comments to 3 or 4 minutes per bill. I know some of you have several bills, so I'll take that into consideration. And for those who need to go a little bit longer, I also encourage you to submit supplemental written testimony if you need more than the time allotted this evening. And I do appreciate your patience and understanding. With that, we will move to Senate Bill 684 for public testimony. And we have Haley Norris, I believe, from the Amnesty International USA Local 1016. Welcome to the committee, Haley Norris. You may begin your testimony. If you could keep your comments under 4 minutes, we'd appreciate it. And I believe you're also testifying on Bill 730.
Yes.
Thank you.
Yeah, I'll be brief. Thank you. Hello, everyone. My name is Haley Norris, and I'm speaking to you on behalf of Amnesty International's Local Providence Chapter 1016. In support of the Attorney General's legislative priorities to protect consumers, renters, and employers, I will address a couple pieces of legislation tonight. As you may know, Amnesty International is a venerable, nonpartisan organization that has been working for human rights for 70 years. We have over 10 million members internationally and hundreds of local groups in all 50 states. Amnesty is committed to protecting consumers from predatory behavior, as well as accountability for businesses who engage in unlawful practices. That is why our chapter supports the passage of S0684. Our state should have robust measures in place to keep everyone, and especially the working poor, undocumented communities, and vulnerable members of our society. Let's rein in corporations and ensure people are put over profits. Our chapter also supports the Attorney General's office in their pursuit of more open and transparent judicial operations, namely in seeking passage of the County Grand Juries Reporting Bill S0730. Many other states have gone through with this experiment, which includes sunset provisions and other protections. Pennsylvania even has a full report you can refer to if you want to see the proof and concept. The facts are that grand jury reporting allows for community members to have transparency in both how and why the grand jury decisions are made. This allows for greater trust in the criminal justice system, and it also gives greater credibility to our institutions. That is why we need to go ahead in order to maintain our civil society. Thank you for your time, and Local 1016 urges you to consider these bills and pass them out to the floor for a full Senate vote now.
Thank you very much, Ms. Norris. Any questions for this witness? We don't see any questions right now. Thank you so much for joining us and for your testimony. At this time, Senator Reptakis, would you like to be recorded in the affirmative on health for further study? You had dropped off at that time. Yeah, I see him raising his hand. He's voting yes to be hold for further study on the bills. Thank you.
Great, thank you.
Thank you, Haley.
Bye. Thank you.
Also testifying on Senate Bill 684 is Jordan Mickman, who I believe is on the line for Center for Justice. Welcome to the committee. You have 3 minutes for your testimony.
Hi, thank you so much for having me. My name is Jordan Mickman. I'm the supervising attorney at the Rhode Island Center for Justice and an active member of the National Association of Consumer Advocates. I've been practicing consumer law for 9 years, and 4 of those years have been here in Rhode Island. And we did submit written comments, so I'll make this as quick as possible just to highlight a few points. The bill here really restores the original intent of the laws before a Supreme Court case fundamentally changed the way the law operates. What the Supreme Court did was they interpreted the word permitted to mean anything that's not expressly prohibited. And that's not what the General Assembly intended when they passed this law. A consumer protection law is intended to be broad and interpreted broadly, not narrowly to prohibit anything that's not expressly prohibited. That's self-defeating. So don't be distracted by the industries that are opposing this bill. This isn't going to duplicate any regulation. The language of the very bill itself, of the law itself, states that it will not duplicate regulation. What the industries are doing here is requesting immunity from liability when they engage in clearly deceptive behavior we all agree is deceptive simply because the regulatory agency hasn't already prohibited the conduct yet, as if regulatory agencies have commented on every single metaphysical possibility. And the very point of view of that bill is to remedy conduct that's not already expressly prohibited. And they're asking for an extraordinary exemption here. The exclusion for regulatory conduct is not intended to be a permission slip for businesses to engage in conduct that's deceptive. A contract that's plainly deceptive cannot become lawful because a regulatory body hasn't opined on the issue yet, or because some bad actor was so clever that they designed a scheme that hasn't been prohibited, or to intentionally avoid a law. Again, scams are constantly evolving. A flexible, deceptive trade practices statute is necessary to remedy these laws, and this law would put Rhode Island in line with all of the other states. There's no need for an exemption to allow parties to engage in deceptive conduct. Thank you.
Thank you very much for your testimony. And you are allowed to submit supplemental written testimony. So if you haven't done that and you want to include more, I welcome you to submit that as well. Yes, Senator.
We did submit written.
Okay, very good. So Senator Archambault also has a question for you.
Well, thank you, Madam Chair. Just a comment. I just want to thank you for your exceptional testimony. Boy, you summed that up. I wish I said it the way you did, but you covered every aspect of it, and I appreciate it. On behalf of the Attorney General and the Senate, I really appreciate your testimony. Thank you.
Thank you. This law is very important. I hope we can get it through.
Any other committee members have questions of Mr. Mickman? Seeing none at this time, thank you for joining us this afternoon.
Thank you. Good night.
Welcome to the committee. I believe we have Julie Hamill from the Rhode Island Judiciary on the line. Ms. Hamill, I believe you're speaking on several bills on behalf of the court. You may begin your testimony. If you could just let us know which ones you're testifying on at the time.
I certainly will, and I will make it brief. Good afternoon, Chairwoman Coyne, Vice Chairman Archambault, and members of the Senate Judiciary Committee. My name is Julie Hamill. I am General Counsel to the Supreme Court, and I am here to speak on 3 different bills. The first one being Senate Bill 724, which seeks to amend General Laws 35-427, which pertains to indirect cost recoveries on restricted receipt accounts maintained by state agencies. Essentially, the statute provides that 10% of all cash receipts which are held in restricted receipt accounts be turned over to the general fund. And the statute does contain certain exceptions, as well as an itemized list of restricted receipt accounts which are not subject to the 10% indirect cost recovery. We're asking that 4 of the judiciary's restricted receipt accounts be added to that list of exempt accounts, and we've identified the accounts in the bill themselves. I would note that the first account the indirect cost recovery account maintained by the Supreme Court. It's already being treated by DOA as exempt from that 10% indirect cost recovery. So this would essentially just be, making the statute reflect what is actually already being done. The second, third, and fourth accounts, which we're asking be added into the list of exempt accounts, hold funds that are deposited in accordance with Rhode Island court orders. And as such, we submit they should be entitled to exempt status. I would further note that the funds held in those three accounts have so far been insufficient to cover the expenses that each account was set up to pay for, which requires an infusion then of cash from the Judiciary's general operating budget to meet those needs. Removing the 10% reduction would essentially assist in maintaining those accounts at an appropriate level. So those are my comments on Senate Bill 724. I'm happy to answer any questions before moving on to my next bill.
Do we have any questions of committee members? None at this time. You may proceed.
Thank you. The next bill is Senate Bill 726, which pertains to the rules of the Unauthorized Practice of Law Committee. That committee by statute is under the governance of the Supreme Court, and the committee is authorized to generate rules which are essentially approved by the Supreme Court and promulgated by the Supreme Court. The statute 112719 that we're seeking to amend provides that the UPLC rules must be filed with the Secretary of State and be open for public inspection. And that statutory requirement has never been an issue because the Judiciary would historically provide courtesy copies of the UPLC rules to the Secretary of State. However, as some of you may know, in 2018 and 2019, the Secretary of State, to her credit, completely overhauled the Code of Regulations that she maintains, and there's a new formatting requirements as well as publication requirements for all of the rules that the Secretary of State maintains. So even though the Secretary of State acknowledges that the Judiciary is exempt from the Administrative Procedures Act and thus is not subject to the publication and commentary requirements of that law, the Secretary of State was still asking that the UPLC rules be reformatted to fit into the revised Secretary of State Code of Regulations. So all that is to say that essentially removing the requirement that the rules of the Unauthorized Practice of Law Committee be filed with the Secretary of State is really just in keeping with the governance of the Supreme Court over this committee, and we would, of course, make those rules available to the public on the Judiciary's website, but we do not want to be in violation of the law because of this practical difficulty. So those are my comments on that bill, and I just have one more, unless there are any other questions on the bill I just spoke on.
Any questions of committee members for 726? Seeing none, you may proceed with the next one.
Thank you. Finally, and very briefly, Senate Bill 735 deals with emergency authority of the Chief Justice. Ironically, we did introduce this bill in 2019 and again in 2020. And while we think the Judiciary has been able to navigate the challenges of the pandemic rather well, this bill will essentially codify the authority of the Chief Justice to take any necessary action in order to ensure the continued and efficient operation of the Judiciary when there are operational disruptions for any reason. And I'm happy to take any questions that the committee may have on that bill.
Any questions for Ms. Hamill on 735? I do not see any at this time. Thank you very much for joining us this afternoon and for your concise and organized testimony. We appreciate it.
Thank you. Good evening.
Now we are moving to Senate Bill 729. I believe we have Lynette Lavenger from the ACLU, Rhode Island, on the line to speak on that bill as well as 803. Welcome to the committee, Ms. Lavenger, and you have approximately 6 minutes for your testimony.
Oh, that's wonderful. Thank you so much, and thank you for taking the time to hear from me as cooperating counsel for the ACLU of Rhode Island. We are opposed to both S729 and S803. I'm going to start with 729. While there are many important laudable goals sought to be achieved, including the expansion of categories protected by the legislation to include national ancestry, color, sexual orientation, gender identity or expression, and disability, we do not support the bill as written. Due to time limitations, I'm just going to focus on Section 3. We also have submitted written testimony. Section 3 would grant the Office of Civil Rights Advocate of the Attorney General new sweeping powers in conducting non-criminal investigations outside of the grand jury process. It would authorize the Civil Rights Advocate to order any person who the Civil Rights Advocate thinks might have information about a potential unlawful activity to appear and to disclose whatever he or she knows, or face a $10,000 fine and possible contempt of court for failing to comply. Empowering a government official unchecked to summon citizens to account or merely to ascertain whether a person is about to engage in unlawful activity is contrary to notions of privacy, freedom of speech, and limited police powers. The Attorney General already has adequate tools at his disposal to initiate and conduct both civil and criminal investigations and to issue subpoenas, which are subject to judicial review when there is an allegation that the Attorney General has overstepped his bounds. The current statute already authorizes the Office of Civil Rights Advocate to review complaints, conduct investigations, and bring civil action. At an earlier time, the Attorney General claimed that he needed these powers in order to investigate law enforcement personnel. But the actual language of the proposed amendment is much broader than that and applies to anyone, including the organizers and participants in protests against police abuse. The ACLU of Rhode Island supports the Attorney General in his efforts to investigate law enforcement agencies and to hold them accountable for acts which deprive individuals of their civil rights. But this proposed language goes well beyond what is necessary to accomplish that goal and does not even mention that goal. We cannot rest on assurances that the Attorney General will not exercise new powers expressly permitted by S729. Regardless of intent, this section represents a chilling overreach by the Department of Attorney General, empowering it to compel speech from all private persons, not just the target of a civil investigation about a wide array of activities. To give one concrete example of its reach, the provision could give the Attorney General broad powers to investigate Black Lives Matter protesters who were believed to have information about the disturbance that took place in downtown Providence after the death of George Floyd. I turn now to S803. While hate crimes deserve condemnation, the ACLU of Rhode Island is opposed to 803 as written. 803 would make it easier to find a hate crime based solely on the written or spoken word and without a direct finding of animus. It would allow a hate crime to be established whenever any person or group is the target of a crime in whole or in part. This in part revision significantly increases the risk that proof of a hate crime will no longer require the state to prove beyond a reasonable doubt that the accused targeted his victim because of a protected characteristic. What does that mean? Would anyone charged with disorderly conduct or property damage during a Black Lives Matter protest be subject to hate crime enhancement because their actions occurred when they were protesting against claims of systemic racism and therefore the criminal conduct which occurred happened in part because of race? Is graffiti or vandalism of a Christopher Columbus statue expressing opposition to treatment of indigenous persons targeted in part at individuals of Italian heritage and thus arguably a hate crime? It would seem that it would support that interpretation. The ACLU is long on record as opposing restrictions on what many, including many members of the ACLU, consider offensive and toxic speech. And this proposed legislation is especially problematic because that speech could be inappropriately used to enhance the punishment imposed on an individual. Similar laws have often been used against members of the groups that are actually most likely to be victims of hate crime. Broadly worded hate crimes give prosecutors and police wide discretion to decide who will face enhanced criminal penalties, and they are just as apt to be used against members of minority communities. One of the first people charged under Florida's hate crime was an African American who, arrested for assault, called a police officer a white cracker. Of course, colorblind enforcement of these laws is appropriate, but it also raises the question as to exactly how helpful they are in addressing the root problem they seem designed to address. On a separate issue, the bill contains a mandatory sentencing provision. The ACLU has long expressed concern that any mandatory sentencing takes away needed discretion in the judicial process, and that is true no matter what the crime. The expansion of this law is particularly detrimental from the ACLU's perspective because the hate crime statute is one of only a handful of state laws that contains mandatory minimum sentences. Due to time limitations, I would respectfully refer you to our written testimony, which addresses additional concerns. For all these reasons, and without in any way questioning the motivations behind the bills, we are constrained to oppose S803 as well. We thank you for considering our views and would welcome any questions on either bill.
Thank you very much, and thank you for staying within the time limit. We appreciate that. Any questions from Ms. Labager? Yes, Senator Archambault has a question for you.
Thank you, Lynette. I appreciate your testimony. I think with respect to the other bill for Senator Casada, I understand your concerns there. That I'll let others speak to that, but you raised some very valid points. Let me just ask you, I'm looking at this bill, and two questions. The first one is, if the redacted language that exists under the current statute, 12-1938, under the Hate Crime Sentencing Act, and that redacted language is what you talked about as the problematic language when it's removed, the actor's hatred or animus towards, if that language were reinserted into the bill, keeping all the other intent, would you have the same opposition?
We think it would. I think in our written testimony we talked about some additional language that would improve things, but we would still have opposition on these other grounds, which is the mandatory sentencing and the fact that the use of hate crimes language to enhance sentencing is often left to the discretion of the prosecutors in a way that doesn't actually serve the desired intent. We believe that there's ample basis under the current laws for a sentencing court to take into account what happened. The in part language is particularly problematic in that regard because it means that it could be a different reason altogether. But if there's any reference potentially in speech or in the written word to something that's considered animus, then it could elevate a particular prosecution from a regular crime into a hate crime, even though that one need not prove that that was the sole motivating factor.
No, Madam Chair, thank you. I understand that. I get that. Perhaps if that language were reinserted, it would assuage any of those concerns. I just do want to point out that the other provision on the mandatory sentencing that you're opposed to is already in law. So I would imagine, I would infer that in the past you have come forth and testified when any issues were raised with respect to this statute on that position, unrelated to the current legislation, because it's not a proposed change. Is that correct?
The ACLU did. It wasn't me personally,
Okay.
but yes, we expressed a bunch of concerns about the original language, and we stand on record as opposed to all mandatory minimum sentences.
Sure, I understand. Thank you very much.
Thank you.
Thank you. Any other questions of committee members? Seeing none at this time, we appreciate your time you took to testify this afternoon.
Thank you.
Next testimony will be on 7:30 for Mr. Michael DeLaurel from the Rhode Island Public Defender's Office. Welcome to the committee. You have 3 minutes for your testimony.
Thank you, Madam Chair and committee members. I'm happy to tell you that my testimony should be brief because we've already addressed this legislation at least since 2019. First, I want to thank the Attorney General for reaching out to us back when this legislation was initially drafted and seeking our thoughts concerning it. Although we take no position on the legislation, we do have some issues that we feel the committee ought to consider before taking any action on the legislation. First, this is a substantial piece of legislation, and that is because Rhode Island has a common law grand jury that is really comes under the umbrella of the courts more so than the legislature. There actually are very few laws regarding the county and statewide grand juries, and those that we do have deal with things like quorums, where and when they sit, and things of that nature. We think that the substantial changes that are made by this legislation, if enacted, ought to go hand in hand with additional protections, such as a more robust involvement of the courts regarding the procedures that this legislation would enable or empower. We looked at a number of different state statutes that have this, and they have in their statutes things like witnesses or targets required that they be advised of their Fifth Amendment rights, a right to counsel, provisions for the appointment of a special prosecutor, more robust involvement of the court in initiating and supervising the proceedings, and a date certain for the proceedings to end. We also think that some actions that have taken place since the last time we met and discussed this legislation are worthy of consideration. We know, for example, that in the state of Pennsylvania, which has a statute like this, that the Pennsylvania Supreme Court convened a special task force to study the way and make recommendations regarding the way in which this the Pennsylvania statute has been utilized. And I provided the committee with a copy of that report via email. That report came out in November 2019. I think the representative of Amnesty International referenced it. But it's interesting to note that because of some of the abuses that have taken place in Pennsylvania, most notably in connection with the Sandusky case and Coach Paterno's firing, that task force made up of criminal justice stakeholders recommended the following. The Investigating Grand Jury Act should be amended to eliminate grand jury reports, or in the alternative, the statute should be amended to preclude a grand jury report from critically commenting on a named or otherwise identified individual unless the comment relates to charges filed against the individual or charges recommended against the individual in an accepted presentment. Lastly, I just want to say that you may recall, Madam Chairperson and committee members, that the last time we discussed this bill, Madam Chair, you asked me a question regarding separation of powers. And
Yes.
Very presciently, I think our Supreme Court in February of 2020 came down with a decision in the In Re 38 Studios grand jury. And the court in that case said that there was no inherent authority in the Superior Court to disclose grand jury materials beyond that which was permitted by Superior Court rule of criminal procedure, given the integral nature of grand jury secrecy. So, Madam Chair, knowing you as I do, I know that you're not going to say, I told you so, but your comments that you made a couple of years ago in connection with similar legislation or identical legislation have proven to be correct, at least according to the Rhode Island Supreme Court. So with that, I'd be happy to answer any questions that you or that the committee might have.
Thank you very much, Mr. Lauro. Any questions for this witness? Yes, Senator Archambault.
Mike, I always appreciate your testimony. Isn't it really the point, though, if the court ruled that the Superior Court can, in fact, make that decision, that legislation can be passed to, in fact, open it up to do just that, to promote the transparency of releasing those grand jury documents. That's the first thing. And the second thing is we have a 5-year sunset carved into the bill if there were any real concerns that it was going to be a runaway train. You know, what are your thoughts on that?
Well, I was interested to read about some of the abuses that happened in Pennsylvania, Senator Archambault, and although I would say as strongly as I can, do I see, if this were enacted, do I see any such abuses coming from this administration? And I would say absolutely not. Most of the people that in responsible positions there I've known for decades, and do I picture them abusing the grand jury process, as was the case in Pennsylvania? And the answer would be no. But, the current Attorney General is not going to be there forever. And the possibility of abuse, as was the case in Pennsylvania, and there's, reams that's been written about what happened in regards to Coach Paterno and, his demise, which really resulted from the inappropriate release of grand jury material. The other thing is that I think the last thing the General Assembly would want to do, I say this respectfully, would be to get into a turf war with the court, especially when its language is so clear in this In Re 38 Studios grand jury case, where I think what they're saying is the grand jury belongs to us. The Attorney General gets to use it and gets to use it appropriately, but the grand jury is an arm of the court. In that decision, the court went on to say that even assuming the Superior Court did have the authority to release this information regarding 38 studios, as the governor requested, that the case had not been made that it was necessary to do that, notwithstanding the great public interest in that case. So I think, hopefully that responds to your questions.
Thank you very much. Yes. Do any other committee members have any questions? Seeing none at this time, thank you for joining us this afternoon, and thank you for your testimony.
Thank you, Madam Chair, and committee members. Hello?
Yes, is this Ryan Holt on the line? Good afternoon. Welcome to the committee. Thank you for joining us. I believe it's Ryan Holt from the Attorney General's office on the line.
Hi, good afternoon, Madam Chair.
Is it Ryan? Okay, great. I believe you're testifying on Senate Bills 731 and 826. If you could keep your comments to about 5 minutes, we'd appreciate it.
Yes, Madam Chair. It's actually 731 and 795.
Okay, 795. Thank you for the correction.
Sure. So I will start with 731, Madam Chair, that you introduced on our office's behalf, and we're very appreciative of that. What this bill would do is it amends the wiretap statute to make felony violations of the human trafficking statute a designated offense, meaning that the AG's office would be authorized to petition the court for a wiretap. To be very clear, the crimes contemplated here are very, very serious offenses, where the trafficker is the target, not the worker. We're talking about forced labor, sexual servitude, crimes like that. This would give our office a valuable tool in the prosecutorial toolbox, as these cases often involve organizations that are very difficult to penetrate and often involve witnesses who are from an extremely vulnerable population, who are unable or otherwise unwilling due to either extreme intimidation or fear for their life to come forward. This will give us better evidence and build stronger cases, and I believe will enhance public safety. And as such, I ask the committee to support this bill. If there are any questions, I'll take them now. If not, I'll move on to 795.
Did you ask if there were any questions?
Yes, I did.
Okay. Any questions of committee members? Okay, you may proceed with 795.
Thank you, Madam Chair. Speaking in support of Senate Bill 795 that Leader Mccaffrey introduced on the office's behalf, and we appreciate that. The Attorney General's office, as many of you know, is our state's law firm, and it's critical to our mission to seek accountability, whether it be financial or for other means, when the state or its citizens are wronged. In furtherance of this mission, we participate in numerous multi-state litigation efforts with Attorney General's offices from around the country. These often involve large multinational corporations and have been on a wide range of issues, consumer protection, environmental, etc., which are all priorities of Attorney General Morona. The funds recovered from these settlements mostly go to the General Revenue Fund and should be directed towards programs that mitigate the issue at hand. For example, a pollution case, the funds should go to environmental cleanup. And the office retains a very small portion of that to be used for the furtherance of these operations, be it for expert witnesses, staff, etc. Current law caps what the office can retain at $65,000 a year, which, if we're talking about large multi-state, multinational cases involving potentially millions of dollars, that doesn't really go very far in moving the ball. If we're able to retain more, we believe we can pursue more of these cases at a more active level and ultimately return more money to the state. Here's how. These offices, these AG's offices, participate in these cases in different levels. The lowest level participating states is where we usually come in. It's pretty little involvement, smaller payout as a result. The next level up is the executive committee, which is more involved, including reviewing some documents and helping negotiate the settlement, etc. And then the highest level of involvement, the lead states, which take an even more active role, and as a result, get a generally higher payout, bigger piece of the pie. Now, some may say, well, Rhode Island's a small state, we're a small office, so how could they take a more active role when you're talking about states like Texas and New York and California, whatever? But Rhode Island is small, but can be mighty as well, and other small states have taken the lead or executive committee slots in years past. I'll give you a recent example that illustrates this breakdown and how
briefly,
it really
please,
impact
Ryan.
the state. Yes, I'm almost done.
Thank you.
So, the Equifax settlement in 2019, Rhode Island was a participating state, recovered $1 million. Vermont, an executive committee state, fewer breach consumers, but similar population, recovered $1.8 million. D.C., fewer breach consumers than us, was a lead state, but recovered $3.9 million. So we believe this is a revenue positive proposal that would allow us to be more active, protect Rhode Islanders, and hold wrongdoers accountable. And as such, I ask that you all support this bill, which give us a tool to fight for the state.
Thank you, Ryan. Any questions for Ryan Holt from the AGs? I don't see any at this time. Thank you so much for your testimony this afternoon.
Thank you, Madam Chair.
Sure. I believe the Secretary of State, Nellie Gorbea, is on the line. Welcome, Secretary of State, to the committee this afternoon. And I believe that you're going to testify on 826, 673, and 674. And I ask that you keep your comments to 7 or 8 minutes if you would on all three.
Yes, Madam Chairwoman, thank you so much to you and to members of the committee for the opportunity to come before you tonight to discuss the revised Uniform Limited Partnership Act and the Uniform Partnership Act. Simply put, these bills would make Rhode Island a better place to do business by setting clear guidelines and modernizing laws that haven't been touched in decades. I would also like to thank Senator Lombardi and the chairwoman for introducing these bills. The chairwoman did a great job, of helping me with this, and I really want to make sure that you understand that what this does is it gives a clear source of statutory authority for issues related to limited partnerships in our state. Right now, Rhode Island's limited partnership laws are based on legislation drafted more than 4 decades ago. Senate Bill 826 would do an updating of these laws to basically put them into this millennium. And it would also put Rhode Island in line with 21 other states that are following the revised Uniform Limited Partnership Act. There's these national models that, you know, a lot of attorneys throughout the different states try to make sure that the laws are uniform so that you can do business transactions much more easily. And my office has worked closely with the Business Organizations Committee of the Rhode Island Bar Association and other groups to ensure that the bill's specifics are really right for Rhode Island. Senate Bill 673 would bring the same benefits I just outlined, but for general partnerships, a different kind of incorporation here. Just so you know, the laws on general partnerships were last updated in 1957 when Dwight Eisenhower was in office, and I know I was not alive then, so it's been a while. And as you know, things have changed a lot. So Bill 673 would update it to standards that are really already being used by 39 states, the District of Columbia, the U.S. Virgin Islands, and Puerto Rico. So adopting Senate Bill 673 would immediately bring clarity and cohesiveness to the general partnerships in Rhode Island. As Secretary of State, one of my main goals is to make sure that our state is a favorable place to begin, maintain, and grow a business. And that's why I'm supporting these bills. My office is working directly with the Uniform Law Commission and is going to be offering a few amendments for the committee's consideration. But I didn't want to pass up the opportunity to go ahead and have this be heard. And I want to thank you for the opportunity to testify today.
Thank you very much for your testimony. And just for the record, I wasn't born in 1957 either, so I think we need some updating. Does any committee members have any questions of the Secretary of State? Are you good with your testimony?
Yes.
Very good. Okay.
Thank you so much, Madam Chairwoman.
Thank you very much for joining us. Awesome. Welcome to the committee. I believe we have Mr. Thomas Heminger. Also, he's from the Uniform Law Commission, speaking on 826, as well as the other uniform laws pertaining to limited partnership and partnership. Mr. Heminger, you have 10 minutes to testify.
Thank you, Madam Chair. I appreciate the opportunity to testify. I understand that you all are pressed for time, and I think the Secretary of State has made the essential points on the partnership and limited partnership bills. The one thing that I would add to her comments is that both of the bills, particularly the one on general partnerships, are designed to accommodate small businesses that form in Rhode Island and are the backbone of our economy, and don't always have lawyers involved in forming the business. And it sets default rules that provide for fairness and equality among the general partners. So it's good for business at all levels, and I'd be glad to try to answer any questions that you or the rest of the committee have about 673 or 826. And then I know there are some other bills, and I'm not sure if you wanted me to address those after the questions or to come back on later.
Yes, no. Any committee member have any questions related to 826 or 673 at this time? I don't see any. You may address the other three bills. I believe you have 674, 801, and 802.
Yes, thank you, Madam Chair. 674 is, I believe, an earlier introduction of what's essentially 826, and I think 826 on limited partnerships is probably the one that the Secretary of State is going to want to pursue, and we support that bill and the proposed changes that the Secretary will be offering at a separate time. On S802, Unsworn Declarations, this is a bill that makes for greater flexibility in the courts, so that sworn statements do not require a notarization if they're used in court. The pandemic has kind of laid bare the difficulties sometimes of getting documents notarized. And September 11, 2001 also laid bare the difficulties of getting documents notarized overseas. So this bill would really streamline procedure in the courts. And again, I'd be glad to try to answer any questions that the committee may have.
Any questions for Mr. Heminger on this bill? None at this time. And then I believe it's 8:02. Is that
Thanks.
Is that the remainder of your testimony?
801, I'm sorry, Madam Chair,
Yes.
on foreign country money judgments.
Yes.
Yes. This is a bill that would modernize Rhode Island law on the recognition and enforcement of foreign country money judgments. We are one of the very few states that does not have a statute that gives clarity to the courts on how to handle these cases. And even our neighbors in Massachusetts have a prior version of this act, but now about half the states have the modern Foreign Country Money Judgments Recognition Act. We've submitted written testimony on this as well as the other bills that provide more detail on how they work mechanically. But the second half of this bill would adopt the Uniform Registration of Canadian Judgments Act. And essentially what that does is it follows the template of the Foreign Country Judgments Act, the first part of the bill, but instead of filing a separate independent lawsuit, the judgment creditor would file a registration with the Superior Court and pay the same filing fee as for a new lawsuit. But it would, because the Canadian judicial system is so close to ours in terms of due process and fairness principles of justice, it would essentially shift the burden to the judgment debtor to make a case that there is something inherently wrong with the Canadian judgment, that otherwise it would become effective on registration. And again, I'd be glad to answer any questions. The only other point I wanted to make is that both halves of this bill will save judicial resources because the courts can just focus on core issues of justice rather than relitigating the underlying merits of every case that was already litigated in another country. Thank you.
Very good. Any questions from Mr. Heminger? I don't see any questions at this time. Thank you, sir, for joining us this afternoon, and thank you for your very concise testimony. Appreciate it.
Oh, thank you, and thank you all. Bye.
Mm-hmm. Good afternoon. Welcome to the Committee on Judiciary. I believe we have Angela Carr, President, Defense Counsel of Rhode Island. Good afternoon. Ms. Carr, you have 3 minutes to talk on 733. I believe that's what you've signed up for.
Yes, thank you. Good afternoon, Madam Chair and committee members. Thank you for the opportunity to convey the opposition of Defense Counsel of Rhode Island to the proposed revisions to the Joint Tortfeasor Statute. DCRI has also submitted a written statement, so I will focus my comments on what I view as the most problematic aspect of the proposed revisions, namely that they do not provide reasonable protections for non-settling tortfeasors. First, there's no requirement that any settlements be made in good faith. Second, there's no provision that settlements be reasonable. And third, there's no mechanism for a non-settling tortfeasor whose rights could be adversely affected to challenge that settlement. I think the best way to illustrate how this can work in a real trial and show the inherent unfairness is to provide an example in the form of a case I tried several years ago. When it was filed, it named multiple defendants. As it made its way to trial, several of the defendants were dismissed. And shortly before trial, arguably the most culpable defendant settled out with the plaintiff, leaving my client and me alone at trial. While we were really confident in the defense of our client and we did secure a defense verdict, had they found our client 1% liable and the jury awarded $2 million, which would not have been out of the question given the relative exposure, arguably my client should have been responsible for $20,000 of that settlement. Under this new scheme, it would be my client would have been responsible for $1.98 million. Not to mention there was over 110% prejudgment interest. Seems to me that that's objectively unfair. So while Defense Counsel of Rhode Island certainly believes that changes are needed to the current joint tortfeasor statute, we believe those changes should be made in more of a holistic fashion as opposed to a piecemeal fashion. And I will just refer the committee to our written statement. Happy to answer any questions.
Thank you. Any questions for Ms. Carr? I don't see any this time. Thank you for your testimony.
Thank you.
Welcome to the Committee on Judiciary. We have Tony DeSisto, Rhode Island Association for Justice. Mr. DeSisto, we have you signed up to testify on 3 bills, 733, 736, and 718. If you could please keep your comments under 7 minutes, we'd appreciate it.
Thank you, Madam Chair. Regarding the joint tortfeasor bill, I have to say that Senator Lombardi gave an excellent summary and presentation on the bill, but based on the testimony that you just heard, from the standpoint of the RIAJ, it's the exact opposite. The current law, as it is, forces defendants to stay in the case, even if they want to settle out, because of the way that it's structured. It's not a dollar-for-dollar set-off on the bill. So this is what I think the committee needs to know on this. You've actually passed this bill for individual cases on several times. You may recall 2 years ago that an exception to the joint tortfeasor law, such as this one, was passed to allow for settlements on the Ringling Brothers case, and also 38 Studios, also on the Fatima Hospital case. All of those bills, not in others too. And at the time, the opposition was, well, if we're doing it for one case, we should do it for all cases. That's why this bill is in. I think it makes good sense. From a judicial standpoint, it's fair to those defendants that want to settle out so they're not forced to stay in the case and drive up the cost of litigations. If you have any questions, I'd be happy to answer them.
Any questions on this bill for Mr. DeSisto? No question at this time. You may proceed to the next one.
Thank you. The next bill is the Products Liability Bill. And what this bill does is separates a huge loophole in the case. Basically, the way the law stands now, if there is a subsequent alteration of a product, it is an absolute bar to recovery if there is an injury afterwards. That is draconian. It is not in line with the rest of the law in this country. And to me, if there is a subsequent change, that should be an issue for the jury to decide as to whether or not under comparative negligence there should be an offset for that. So I think this is a fairness bill and worthy of consideration. Bring Rhode Island in with the rest of the country. If you have any questions, I'd be happy to answer them.
Any questions from committee members on this bill? I don't see any at this time. You may proceed with your next bill.
The next is the 718, the Residential Landlord Tenant Act. This is a tenant's rights bill. Basically, the requirement is that the landlord who is renting an apartment maintain a liability insurance policy of at least $100,000. And when the license is renewed, furnish to the tenant a copy of the face sheet of the insurance policy. This lets the tenant know that the apartment is properly insured, and also, by the way, has an added benefit. Because there is insurance on there, the insurance company does the inspection, make sure that it's a safe apartment. It's great for tenants. If you have any questions, I'd be happy to answer them.
Any questions about 718 for Mr. DeSisto? No, we don't have any questions at this time. Thank you very much for your testimony.
Thank you, Madam Chair. Have a good evening.
You too. Welcome to the committee. I believe we have Rory Whalen from the National Association of Mutual Insurance Company on the line to speak on Bill 736. Are you with us?
I am, Madam Chair. Thank you very much. Thank you, members of the committee. I'm speaking on two bills tonight, Senate 684 and Senate 736.
Okay, you have 5 minutes to speak.
Thank you. I will be brief. As you know, the insurance industry is heavily regulated by the state of Rhode Island. And current law properly empowers the insurance division of the Department of Business Regulation to regulate insurance. This provides for a fair and uniform regulatory regime that is applied to all insurers, reducing the risk that any single insurer would be subject to an arbitrary or capricious government action. Accordingly, division staff has deep knowledge and expertise in these matters and is uniquely qualified to oversee and enforce these regulations. This bill, however, seeks to impose an additional unnecessary regulator without just cause or merit. Moreover, this dual regulatory scheme would likely lead to jurisdictional conflict and confusion. Under this legislation, an exemption from the AG's oversight is still permissible. However, this bill imposes the burden on the entity to prove it is allowed, rather than on the government to prove that it is not. Moreover, the proposal allows the exemption if the specific activity and manner in which it's performed is expressly authorized by the agency. Consequently, where there's an activity that has been acceptable in the past, perhaps for many, many years, since it was never curtailed by specific regulation, that activity could now be forbidden and not subject to the exemption unless the division expressly allows it. And then lastly, on this bill, the creation of a private right of action will just result in crowded courthouses, unwarranted and unnecessary litigation, the expense of which will be ultimately borne by Rhode Island consumers. I'm happy to take any questions before I move on to Senate 736.
Any questions on 734 of this witness? No questions. You may proceed with your next testimony on Bill 736.
Thank you, Madam Chair. This legislation, NAMIC, we also oppose this legislation. It represents a drastic departure from current law by removing the justifiable civil liability protections manufacturers or sellers have in cases where their product was altered by another party, and when said altered product resulted in personal injury, death, or property damage. Enactment of this legislation would open the floodgates to unwarranted lawsuits on liability for parties whose products were altered or modified without their knowledge. The bill simply seeks deeper pockets. And I'll give you an example of what this bill would permit. A consumer purchases an ATV for his child, and it's equipped with an engine that produces a maximum speed limit of 30 miles an hour. Then the father of this child, contrary to the manufacturer's notice of use and instructions, successfully modified the engine to permit the ATV to exceed the 30-mile speed limitation, resulting in an accident that causes damage to the father's home. Under this bill, the father of that child could bring a claim against the manufacturer of the ATV, even though it was the father's action of altering that product that resulted in the damage. I hardly think that is in any way fair or just. And in conclusion, as I said, liability should rest with the party that is responsible and not the party that has deeper pockets. Again, I'm happy to take any questions and very much appreciate this opportunity.
Thank you for your testimony. Any questions from Mr. Whalen? All set. I don't see any questions. Thank you for your testimony this afternoon.
Thank you, Madam Chair.
And we have our last witness for this evening, Mr. Keith Hoffman from the Attorney General's Office. Welcome to the committee, and I believe you're speaking on Senate Bill 803 and 729.
Yes, Senator, thank you. And I want to thank the entire Judiciary and committee, and specifically Senator Quesada for sponsorship of S729, which I think I'll begin with this afternoon, and then move on to 803 if it pleases the committee. Thank you. So my name is Keith Hoffman, and I'm testifying in my capacity as the civil rights advocate of the Office of the Attorney General. Under Attorney General Noronha, we prioritize the prosecution of hate crimes and police misconduct in our office. And so I want to start this afternoon with the on-the-ground reality that all of the senators on the committee know, because all Rhode Islanders know the pain and turmoil the past year has brought as our communities have grappled with bigoted violence and systemic racism. We've searched for ways to bring about racial justice in Rhode Island, and this bill is one part of the solution to this monumental challenge of our time. This legislation ensures that the Attorney General can pursue discriminatory actions that are intended to threaten or harass any person because of their actual or perceived race, religion, ancestry, national origin, color, sexual orientation, gender identity or expression, or disability, expands other civil rights protections beyond race, religion, and national origin to include a person's actual or perceived sexual orientation, gender identity or expression, or disability, adds authority to stop sustained and repeated or so-called patterns or practices of constitutional or civil rights violations, and finally adds authority to investigate with just standard civil investigative tools found elsewhere in the law. This bill affirms Rhode Island's commitment to the fundamental principle that every person has dignity and thus the right to live free from discrimination and harassment. With regard to pattern or practice investigations, the bill would ensure that where a police department engaged in systemic deprivations of Rhode Islanders' constitutional rights, the Attorney General would have the ability to investigate and stop the misconduct, bringing the Attorney General's authority in line with states like Colorado, California, New York, and the U.S. Department of Justice. Finally, the bill adds a standard, as I said, civil investigative demand section. This is just like the Attorney General's civil investigative demand in the Deceptive Trade Practices Act, which is, again, already in law. Just to respond briefly to some of the concerns raised by the Rhode Island chapter of the ACLU. This really is an important provision, a very important provision that would ensure that misconduct can be thoroughly investigated and can actually help to bring out-of-court resolutions to violations, and most importantly, is subject to court oversight. So this does not create any sort of roving commission. The authority is subject to court oversight and, of course, bounded by the First Amendment and the elements of the law. So thank you all again for the opportunity to provide testimony on S729. And,
Mr. Hoffman, let me see if any committee members have any questions for you on 729 before you begin 803. Any questions for committee members? Okay,
I have a question, but it's not really a question. It's just a concern after I heard this testimony from the ACLU. And,
go ahead, Senator Quesada.
I wanted to make sure that what she said before. Could you clarify a little bit more about the ACLU question about it and their concern about this bill, because they're not in favor of this bill at all?
Right. So I can. Thank you, Senator. With all due respect to the Rhode Island chapter of the ACLU, our office completely disagrees with their legal analysis on this bill. With regard to, for example, this idea that the bill could be used to target people who threw things at the Columbus statue or Black Lives Matter protesters, it truly could not be used in that way, and of course is not intended to be used in that way. Again, the bill is subject to the First Amendment, and it is subject in the civil investigative demand authority that I believe the ACLU most took issue with, is found elsewhere in the law in Rhode Island and around the country, and of course is subject to court oversight. So this idea that that the bill creates a roving commission that can go and seek testimony from protesters really just does not fit with the actual text of the legislation.
Thank you for that explanation. Any other questions, Senator Quesada? You are muted. Okay.
Possible. Thank you, Madam Chair. I would like to see if possible you can get in touch with them and maybe you guys can be together and make this bill better. That everybody will be happy about it.
Did you?
Absolutely, Senator. I will certainly take that back to our office and see about doing that. Thank you.
Thank you very much. And next, I believe you have Senate Bill 803 you'd like to speak on.
Thank you. Yes, and I'd like to thank Senator Archambault for sponsoring this bill. So across the country, we're all aware that hate crimes are on the rise. Over the last several years, we've witnessed horrifying hate-motivated mass shootings, an increase in crime against people in the Asian American and Pacific Islander, or AAPI community, and the rise of a new generation of bigots whose goal is to undermine the social fabric of our society. This bill is one part of a necessary response to these people who would try to divide us with their hatred, but it's not the only necessary response. Still, it's an essential element in ensuring that prejudice in Rhode Island can be confronted and overcome. The Attorney General proposed this legislation to ensure that the office can pursue hate crime cases when there's evidence a perpetrator is motivated by gender identity or expression of a victim. That's something that many other states already have in their hate crime law and really must be provided for under Rhode Island's hate crime law. It codifies the Attorney General's existing authority under the law to bring so-called mixed motives prosecutions. And I want to just briefly touch on this because, again, this is an issue that was raised by the Rhode Island chapter of the ACLU, which I believe, I don't want to mischaracterize their position, but I believe that they generally just do not support hate crime laws. But this mixed motives prosecution in this language, is in part language, actually adopts kind of the model language statute from Wisconsin and tracks the state of the law in many other states like Massachusetts and Delaware. So this really is not some massive expansion of the Attorney General's authority. It's something that's very much in line with best practices in this area. The bill also ensures that the Attorney General can bring an action in a case where a victim is targeted due to their association with a member of a protected group. For example, a person who's targeted because they're married to a person of a different ethnicity. Again, just a necessary a thing that we must be able to do in line with the federal law and best practices. The bill would require a defendant convicted under the Hate Crime Sentencing Act to undertake educational or community service directly related to the community harmed by his or her offense, and would ensure that there's an appropriate sanction when a perpetrator who's motivated by prejudice destroys or defaces commercial or public property. Because under the law today, it's unclear whether such prosecution could go forward when the property at issue is public or commercial property as opposed to private property. So as an example, a few weeks ago, a local police department investigated a swastika that had been burned into public property with a blowtorch. So this amendment would allow cases involving crimes like that, involving property not owned by the person who's targeted due to that person's protected trait, to be prosecuted under the hate crime statute. The bill ensures additionally that the community impact statements can be provided in district court cases where misdemeanor hate crimes are generally prosecuted. And finally, just to respond to one of the other Rhode Island ACLU points, the removal of hatred or animus language is, again, in line with model language. So, for example, the federal hate crime law, the Matthew Shepard Act, has no mention of hatred or animus. That was one of the reasons that we chose to strike that language. Again, just in line with best practices. So these amendments really provide necessary technical improvements to Rhode Island's existing hate crime sentencing enhancement statute, which is one of many sentencing enhancements under Rhode Island law. We have enhancement for domestic violence, for certain firearm-related offenses, crimes involving elderly victims. So, while technical amendments to the hate crime law would ensure that when hate crimes do happen in Rhode Island, we have the right tools available to respond. So, thank you again for the opportunity to testify, and I am, of course, available for any questions you might have about this bill.
Thank you. Any questions of committee members? Okay, I don't see any at this time. Thank you very much for your testimony.
Thank you, Senator.
And with that, I would like to thank the witnesses and our committee members and sponsors for understanding our time limitations this afternoon. And with that, I'll entertain a motion for adjournment. Moved by Senator Archambault, second by Senator Oyer, Casada, and Senator Lombardi. All in favor? Aye. Aye. And we are adjourned.